Well, good morning and welcome to the 13th in our series 39 from 39, the webinar series which aims to provide you with your fix of key legal developments in your specialist area of practice without detaining you for too long. This week's episode is entitled Pollution, Home and Away, and it's not, I'm afraid, about the flotsam and jetsam of Summer Bay in New South Wales. So anyone who has tuned in for that may want to discreetly leave the meeting now. Instead, the plan is for each of our excellent two speakers to devote a little under 20 minutes to their chosen topics, which should allow a bit of time afterwards for any questions you'd like to pose by means of the Q&A function at the bottom of your screen. So first off, we have Stephanie David, one of the talented juniors here at 39, who is fast developing a specialism and stellar reputation in the area, amongst others, of environmental law. Steph has a wide-ranging practice which spans public and private law, and she is well placed to address the issue of toxic torts, with particular reference to the recent judgment of the Court of Appeal in the Vedanta case. In fact, I can see that we've already had a question on Steph's presentation, so I'll give her fair warning of it now in the hope that she might be able to pick it up as she goes along this morning. And the question, Steph, is, given the decision in Vedanta, what does the presenter, that's you, think of the claimant's chances of success in the forthcoming Supreme Court decision in Okpabi and Shell? Following on from Steph, we have Tom van der Kloot, who switched last year to the bar from practice as solicitor at Freshfields, specializing in environmental, product liability and regulatory disputes. He and I have recently, though it was pre-COVID, so may not seem so recent anymore, been grappling on behalf of a client with the Convention on International Trade in Endangered Species of Wild Fauna and Flora. So I have first-hand experience of how beneficial it can be to practice first as a solicitor before coming to the bar. It did make me wonder whether we ought to make this a prerequisite for practice at the bar, as they do rather sensibly in Scotland. In any event, with the benefit of his professional background and specialisms, Tom will be able to enlighten us as to the latest developments and direction of travel of the law as it relates to river pollution in England. His presentation also happens to be extraordinarily well timed, coming as it does just 3 days after World Rivers Day. Further details of both speakers can be found on our website, where delegates will also be able to access a recording of this episode. It is being recorded in due course, and indeed recordings of past and future episodes too, with episode 14 in our series scheduled for a fortnight's time. So without further ado, I now hand over to the first of our two speakers, Stephanie David.
Thank you, Richard. As you said, I'll try and incorporate the answer to that question as we go through the slides. Before I do so, I need to just set a little bit of context to my talk. So the focus this morning is going to be on claims arising from pollution overseas that can be litigated in the courts of England and Wales. The most obvious example of the oil spill cases, which then have an impact upon the health and livelihoods of local inhabitants. For those that are watching, you might also be familiar with the more now historic case from 2006, which is the Trafigura case, which related to about 30,000 claimants in the Ivory Coast, bringing a claim against Trafigura in relation to the dumping hazardous waste in and around the city of Abidjan. What ultimately came of that case is that it was settled, but the settlement, as far as we are aware, included issues with regards to personal injury. The focus today in my talk, given it is quite a short talk, is on the Supreme Court decision in Vedanta and Lagawi. This particular case concerns a claim against a local subsidiary and a parent company incorporated in this country. I think what's particularly interesting about it is the factual considerations that need to be taken into account when determining whether or not a parent company owes a direct duty of care to the claimants. So briefly kind of setting out some context to the Supreme Court decision. The Chandler and Cape case from 2012 is quite an interesting case. The Court of Appeal in that case found the parent company of a subsidiary owed a duty of care to the claimant in the context of exposure to asbestos. What is important to note at this stage is that parent company liability isn't a bespoke category of negligence. The court was at pains to emphasize that it essentially applies the ordinary principles of the law of negligence. But what the case does helpfully do is identify some circumstances in which it might be found that a parent company owed a duty of care to the claimants in question. And you'll see there that the 4 circumstances within that case that justify the duty of care are laid out. So the first one is essentially when the businesses of the parent and subsidiary are essentially the same. The second is where the parent company has superior knowledge in relation to some aspect of health and safety in that particular industry. The third is in relation to the subsidiary system of work and the parent company knowing that that system of work was unsafe. And the fourth is that the parent company knew or ought to have known, or ought to have foreseen, I should say, it's a constructive knowledge point, that subsidiary would be relying upon the superior knowledge of the parent company for the employee's protection. So I'm going to briefly touch upon this case, which relates to the question that I have been asked. I'm going to set out the judgment in the Court of Appeal now and come back to the Supreme Court decision after I've looked at Vedanta in more detail. So this case, the case of Ogbafi, it related to an appeal from the first instance decision of Mr. Justice Fraser sitting in the TCC. The actual case concerned whether or not there was an arguable duty of care by the Royal Dutch Shell for the claimants. The decision was appealed on various grounds, but what ultimately was decided was that the majority held that the Royal Dutch Shell did not owe a duty of care. And that was essentially applying the traditional tests from Kapara and Dickman, with which we'll all be familiar. They accepted that there was foreseeability, but the main issue was in relation to proximity, and that in light of the evidence currently before the court, bearing in mind that the consideration was whether there was a triable issue, so it wasn't determining the issue conclusively as it would do in a final trial of the case, but they considered that in light of the evidence before the court, that there was insufficient evidence to say that the Royal Dutch Shell had sufficient degree of control of the operations of its subsidiary to establish the necessary proximity at trial to support the claim that RDS owed a direct duty of care. The next point was in relation to obviously whether it's fair, just and reasonable for Royal Dutch Shell to owe a duty of care to the claimants. And the majority held that it wasn't fair, just and reasonable to impose such a duty. The first point, which is one I'm going to come back to, which is in relation to the importance of multinational parent companies conducting themselves in a way that's consistent with international standards. And what the majority of the court found was that whilst that might be a laudable principle as an abstract principle, it's not sufficient to give rise to a duty of care. And I will come back to that because it does then feed into published materials by a parent company. But ultimately, taking it in the round, what the majority of the court found was that it could not be said that Royal Dutch Shell owed a duty of care on the basis of that it assumed responsibility for devising a material policy and the adequacy of which was the subject of the claim. And that could form the basis of saying that they had sufficient control over the operations in Nigeria. Lord Justice Sales dissented in that case. And it is worthwhile looking at his judgment, particularly in the context of this case going to the Supreme Court in June of this year. What he said is that whilst setting global standards alone would not be sufficient to lead to an imposition of duty of care on behalf of Royal Dutch Shell. It must be placed in the broader context of the claimant's case. And what he ultimately considered was that within the context, those policies and published materials go to then the practical and executive control by Royal Dutch Shell over the affairs of its Nigerian subsidiary. And so what he said was, taking the case in the round and considering the evidence from Professor Siegel and the production of the Shell Control Framework and other specific framework documents, he considered the claimants have a good arguable case that they could establish a duty of care at trial. What was also important is he flagged that in his judgment, one must consider disclosure further down the line, because so the next step of the proceedings would be looking at disclosure from the parent company. So now I'm moving on to the key case for this morning's talk, which is the Supreme Court case of Vedanta Resources and Lugawi. So this case was concerned with a jurisdictional issue in relation to claims brought by just over 1,800 Zambians in relation to toxic emissions from the Janga copper mine that had damaged their health and farming. The claims were brought in common law negligence and for breach of statutory duty. And the defendants, there were two defendants. The first one were the owners of the mine, which is Konkala Copper Mines, incorporated in Zambia. And the second one was the parent company, which is Vedanta Resources, which is incorporated and domiciled in the UK. So it is just worthwhile flagging at this stage that the arguments before the court were quite technical, because ultimately they concern jurisdiction over both of the defendants. With regards to Vedanta, the issue was whether or not the claimants could rely on the recast Brussels regulations to establish jurisdiction in relation to the affairs of its subsidiary in Zambia. And in terms of the Zambian company, so KCM, that's essentially the foreign defendant, and they were seeking to have service of the proceedings set aside. The claimants were relying on the necessary or proper party pathway within the civil procedure rules. And essentially, as you'll see in the next slide, what that required to do as part of their application is for consideration to be given as to whether or not there's a real triable issue against the anchor defendant, i.e. the defendant in this jurisdiction, so Vedanta. So the key issue for the court, I just laid it out there, which is whether or not Vedanta sufficiently intervened in the management of the mine to incur itself a common law duty of care to the claimants. And I've laid out the kind of key points to take from the leading judgment from Lord Briggs. But essentially, he emphasised that there's no specific doctrine in relation to legal responsibility for parent companies. You do have to look back at first principles, and that's the case of Kapara and Dickman. He further emphasised that Chandler and Cape was not an authority to the effect there is a bespoke or niche area of law in relation to parent companies, but it emphasises the circumstances within which you might be able to establish a duty of care. In terms of policies, what is interesting is that he indicated that policies that are concerned with minimising the inherently dangerous impact, if they are shown to contain errors and implemented by the subsidiary company and cause harm to third parties, that might indeed be a factual circumstance which could give rise to a duty of care. Furthermore, where a parent company takes active steps to implement a policy by training, enforcement, etc., or whether it holds itself out to exercise such a degree of supervision over its subsidiaries, then indeed that can also form a basis from which you can establish a duty of care. So this is the key extract really from Lord Brooks' decision, which is in relation to the published materials. Because as I said, in the case of Agabapi before the Court of Appeal, the majority of the court had considered the published materials weren't sufficient in and of themselves to give rise to a duty of care. But what's important here is they've said that the assumption of responsibility can be read from the published materials, insofar as those published materials might suggest that the parent company is actually seeking to enforce those standards within the published materials. So, as I said there, he considered there is well arguable that they could establish a duty of care by Vedanta in relation to the claimants. It is important to flag that that is by no means the end of the matter, because whilst a real tribal issue was a key matter to be decided by the Supreme Court, they then went on to consider forum nonconvenience and whether or not the courts of England and Wales were the proper place to determine this case. And taking everything together, Lord Briggs actually did determine that had he been deciding the case, then arguably Zambia would have been the proper place for these proceedings to progress. However, that is subject to whether or not substantial justice could be achieved in Zambia. And he ultimately concluded that given the nature of this case, the need for extensive expert evidence, the practical issues with regards to funding such a claim, and the need for legal expertise to deal with the extensive documentary and expert evidence, that he didn't consider that there was a risk, that substantial justice was not to be achieved in Zambia. So following on from Vedanta, there's another case that was heard in the High Court this year, which is the case of Jalo and Royal Dutch Shell. That case was concerned with a number of interim applications. The broader claim is a claim in negligence and nuisance brought by over 27,000 claimants in relation to oil spills off the coast of Nigeria. One particular application was in relation to jurisdiction, and the High Court confirmed following Vedanta that it would indeed have jurisdiction against two of the defendants. It is important to flag that the issue of duty of care was not considered in any detail because they had the interim applications to address, and obviously they decided that would be a matter further down the line once there was further disclosure. But it was followed in relation to the abuse of EU law point, which is Article 4 in the recast Brussels regulations. And then just coming back to Agape, which is the question I was asked. Yes, Agape was appealed to the Supreme Court. It was heard on the 23rd of June this year. And interestingly enough, Lord Briggs was also sitting on the panel of 5 in the Supreme Court. Essentially, the appellate's argument was that the majority in the Court of Appeal applied too restrictive a test when considering the duty of care, and they failed to take into account the potential disclosure further down the line once it had been considered that there was an arguable duty of care. So the specific question that the Supreme Court was considering, and I'm going to read this out, was whether and in what circumstances the UK domiciled parent company of a multinational group of companies owe a common law duty of care to individuals who allegedly suffer serious harm as a result of alleged systematic health, safety, and environmental failings of one of its overseas subsidiaries as the operator of a joint venture operation. And the reason I kind of flag and put emphasis on those final few words is because Lord Briggs and Vedanta made a really interesting observation, which is ultimately this turns on the facts of every individual case. And you can have a broad spectrum of management structures where on the one hand, you have a parent company that's no more than a passive investor in the subsidiary. And in those circumstances, potentially it would be difficult to establish that there is a duty of care to claimants. But on the other end, or the other extreme, you have a parent company with a very clear vertical directive approach, and they do control what's going on the ground. So the reason I flagged the words joint venture operation, then clearly that will play into consideration of the actual model of management between Royal Dutch Shell and its subsidiary. I obviously can't, unfortunately, I don't have a crystal ball. There's no clear answer as to which way the Supreme Court would go. But certainly bearing in mind Lord Justice Sale's comments in his dissenting judgment before the Court of Appeal, and the emphasis of Lord Briggs's judgment in the Supreme Court in Vedanta, you would think there are good grounds for the appellants being successful in that case. I'm going to touch very, very briefly on the kind of broader implications of the Vedanta decision. And I know this might come up in discussions with Richard further down the line. First of all, I think there's an interesting question as to the role of claims in tort. In many ways, it's sort of a broader discussion for a doctoral thesis, but in terms of considering the role that tort law can play when you have issues of overseas pollution that impact upon local people, particularly their health, but also their livelihoods. It's interesting to think about the actual different schools of thought as to what role tort law plays in society. Is it concerned with compensation? Is it the vindication of rights? Is it to act as a deterrent? Or is it more so concerned with corrective and distributive justice? And I think it's important to kind of consider those different factors when you are thinking about the bigger picture and how tort law fits alongside perhaps international human rights standards or the Ruggie principles, which I referred to there. Because I think there's potentially an argument for saying that the international human rights principles, which obviously differ from domestic rights, which have been incorporated into English law by virtue of the Human Rights Act, the international standards aren't directly enforceable in the same way. So how do you actually seek a remedy for individuals affected? Again, I think this is the point that we're going to come to, but I think it's important just to bear in mind, maybe there are two observations I have at this stage. The first one is that with Vedanta, there's obviously a risk that parent companies will intentionally set up their management structures so that they essentially fall within the passive investor category of companies, in which case I think it will be more difficult to establish a duty of care, and therefore tort law might sit at odds with standards in the Ruggie principles or international human rights standards. But my second observation is that, you know, arguably there's a role for the two of them in parallel, insofar as the international human rights standards have aspirational value, they go to the reputation of a particular company. And it might well be that if shareholders and the public consider those factors are important, there is pressure on a particular parent company to ensure they do exercise the necessary control over their subsidiary. So there's a couple of points to bear in mind. My final point is just in relation to flagging the fact that by virtue of these claims being inherently international, you might end up with proceedings in other jurisdictions. I just flag that, you know, there are proceedings also in the Netherlands against Royal Dutch Shell. But that concludes my talk. So I'm going to hand over to Tom.
Okay. Good morning, everyone. Hopefully you can all see the slides there. Hopefully I've managed to successfully share them. I'm going to be dealing this morning with the home aspect of the talk, so river pollution and water quality issues in England. I think my video's not on. I do apologise for that. Give me 1 second. It looks like I might be having a slight connectivity issue on the video. I do apologise, everyone. So what I'll do is share the slides and continue orally, and hopefully the video may pop back on in due course. So I'm going to be dealing this morning, as I said, with river pollution and water quality issues in England. Sorry, let me. Right, so you shouldn't help you able to see the slides. I do apologise for those technological issues. So at least you got the slides, even if you haven't got my face. And the topic this morning has been prompted by coverage such as this that we saw at the end of the summer. This extract is from The Guardian, but it was covered in a number of other news stories. And what lay behind this story was the release of data by the Environment Agency on the 17th of September. And those statistics revealed that 14% of England's rivers are of a good ecological standard, and none of them are of a good chemical standard, meaning that overall, no rivers in England can be said to be in good health. And agricultural runoff and raw sewage discharge were cited as key issues in causing that. So that prompted substantial news coverage. The standards referred to are the standards set out in the Waterworks Framework Directive. And in this presentation, I'm going to be taking a brief look at the structure of those standards before then looking at the possible direction of travel going forwards. And as Richard's already observed, it also seems an appropriate moment to take stock, because we have just gone past World Rivers Day on the 27th of September. So the current water management framework is set out in the Water Framework Directive, and I think it's worth setting this very briefly in its historical context to understand how that legislation has developed. There was an early wave of European water legislation from the mid-1970s onwards, which focused on standards for rivers and lakes used for drinking water abstraction. There was then a second wave of European water legislation from the late 1980s into the early 1990s, which began to look at wider pollution issues such as urban wastewater and agricultural runoff. By the mid-1990s, there was growing pressure for a fundamental rethink of the structure of EU water policy. And although considerable progress had been made in tackling some of those individual issues, there was a feeling that that policy was very fragmented, both in terms of its objectives and in terms of the means it used to achieve them. And so there was a momentum towards creating a single piece of framework legislation that would take a more holistic and ecological approach to water quality management. And that's what led to the framing of the EU Water Framework Directive. And the quote I've produced on the slide here, "Water is not a commercial product like any other, but rather a heritage which must be protected, defended, and treated as such," is taken from the recitals to that directive. And it's quite a strong mission statement. And it was also reflected in the way that the directive took a more holistic approach to river basin management by creating the concept of river basin districts, which were areas designated not according to traditional administrative or political boundaries, but by the catchment area of the river. So the unit of water management would be the hydrographical and geographical unit applying to the river rather than an administrative one. And that was an approach which had been found to work well on continental Europe for rivers which crossed national boundaries, but now is one that applies to rivers within national boundaries as well. In terms of the way that the directive set water standards, it created two central concepts: good ecological status and good chemical status. Good ecological status is an indicator which looks at the quality of the biological community within the river, the hydrological characteristics and the chemical characteristics. And the chemical status looks at compliance with quality standards established for chemical substances at a European level. And the directive assesses these indicators according to four criteria. They are biological quality, so that's fish, aquatic flora, and so on. Hydromorphological quality, which is the riverbank structure, the river continuity, the substrate of the river. Thirdly, physical chemical quality, so temperature, oxygenation, nutrient conditions, and so on. And finally, chemical quality, which refers to the environmental quality standards for river basin specific pollutants. In addition, under the one out, all out rule, if rivers fail to meet the applicable standards in any of those 4 categories, they can't achieve the good water status, which is the overall requirement of the directive. So that good water status was the target that the directive set, and it was originally meant to be met by all freshwater rivers in the EU by 2015. That wasn't achieved, which is a reflection of the fact that this directive has generally been seen as a very ambitious piece of legislation. The European Commission carried out recently a 2-year evaluation programme of this legislation and concluded at the end of last year that it remained fit for purpose. And the Commission also confirmed in June of this year that it wouldn't be amending the legislation, but would rather be focusing on its implementation and enforcement. So that's broadly where we are in terms of the status of the EU regulatory regime around river pollution and water quality. I now want to move on to consider briefly the possible directions of flow, as it were. And the first aspect that I want to highlight is that we are, for obvious reasons, at a regulatory juncture because of Brexit. The Water Framework Directive will remain part of UK law following Brexit, and it's transposed into UK law under the Environment Bill 2020. That bill doesn't, in my view, create a fundamental change to the river pollution and water quality management regime in the UK, but it does give, for example, the government the power to make secondary legislation in relation to that topic. So there could be changes. There could be changes on the way. We've also seen the publication of a new national framework for water resources by the Environment Agency in March of this year. And the Environment Agency has also recently closed a consultation on river basin planning. That closed on the 24th of September. So we will be seeing the policy results that come out of that. In particular, there will be new draft river basin management plans. So there are a number of different regulatory irons in the fire, you could say, but none of the ones listed there, in my view, amount to a fundamental reform of the Water Framework Directive. However, there were some comments made by Sir James Bevan, the Chief Executive of the Environment Agency, in a speech to the London Chamber of Commerce and Industry early in August of this year. What he said was, I think we should also consider reforming one of the totemic EU laws, the Water Framework Directive. And he went on to look at 2 problems which he saw with that directive. He said the first is that it can underplay where rivers are in a good state or where improvements have been made to those that aren't. Right now, only 14% of rivers in England qualify for good status under the Water Framework Directive because most of them fail on one or other of the criteria. But many of those rivers are actually in a much better state than that because most of them now meet most of the criteria across England. 79% of the individual water framework indicators are at good status. He went on to say that the second problem with the one out, all out rule is that it can force regulators and others to focus time and resources on indicators that may not make much difference to the actual water quality. And he gave the example of heavily polluted or engineered rivers in urban centres, which could never be restored to their natural state, which is the idea behind the ecological quality indicator. It's meant to, in effect, indicate how close to its natural state the river is. And what he said was, perhaps that can never be achieved. And he concluded his comments by saying he didn't think that the Water Framework Directive was a candidate for repeal because he saw it as the driver of a lot of improvement, but it could be a candidate for what he called thoughtful reform. Now, those comments in themselves attracted quite a lot of media interest and quite a lot of criticism because, of course, in the context of Brexit, many people are worried about the watering down of environmental standards. I don't express a view on that in today's presentation, but I think what I'm trying to illustrate is that while none of the current regulatory irons in the fire, if you like, in my view, present any kind of fundamental reform to the scheme under the Water Framework Directive. Clearly, Brexit is going to present an opportunity for some changes to be made. And at present, we don't have much of an indication of where exactly that might go, but it's certainly a watch this space. And I think there are certainly going to be some regulatory meanderings of some kind. The final possible direction of flow is the possibility of increased legal action around water quality. I've put there a picture of Fergal Sharkey, former lead singer of the Undertones, and he is an environmental campaigner also. And there are some news reports of a potential judicial review of the Environment Agency by him and a legal team from the Good Law Project. I haven't actually seen that posted on the Good Law Project's website or seen any confirmation of it, but it does suggest that there may be a growing interest in water quality as a front line for environmental public interest litigation. I put there, could water quality be the new air quality? And what I'm suggesting there is that in the same way that over the last 5 years, air quality has been a space of very high activity in terms of public interest litigation and government policy focus, perhaps water quality may become more prominent in coming years, given the currently problematic status of English rivers in terms of pollution, and given the potential changes in regulation that we could have, and particularly this debate about how you measure how polluted a river is and how you use that data to inform where regulators should focus their efforts. That concludes my talk for this morning, and thank you very, very much for listening in.
Well, thank you very much, Tom and Steph. Tom, we still can't see you, but we could very clearly hear your presentation. Thank you for that, and thank you, Steph. We have had a couple of questions coming in, and we've got a few minutes. You appear as if by magic. So one of them, we've got a question coming in. What role have the criminal courts played in controlling water pollution in the UK? I'll have a go at that, and then Steph and Tom, perhaps you could come in if you want to. My take on that is that they played quite an important role in two ways, one direct and the other indirect. The direct role that they've played followed on from the 2014 environmental sentencing guidelines, which some of those who are tuning in today may remember how difficult it was in the past, before 2014, to advise clients as to what likely fines they might face as a result of pollution incidents, including water pollution incidents. It was really quite an arbitrary exercise in many cases, very difficult to predict or advise upon. The sentencing guidelines changed that. They provided some structure, they offered parameters for all cases save for very large organisations. And it's in respect of those very large organisations that I think the courts have had their greatest impact, because possibly as a result of these sentencing guidelines, the courts have felt more emboldened to issue very, very significant fines, particularly against very large organisations that fall out with the limits of the sentencing guidelines. One only has to look at companies like Thames Water to understand the very, very, very large sums that have been imposed in recent years, much larger than had been imposed before those guidelines existed. The indirect way in which the courts have had an effect is through enforcement undertakings. Now, of course, when a polluter volunteers an enforcement undertaking, it is in order to avoid the involvement of the court, but it is because of those hefty sentences that many polluters choose that option where the statutory regime permits an enforcement undertaking to be offered, and they are very often a much better method of addressing pollution incidents than the criminal courts, because they are more nuanced and they allow for remediation and payments into particular funds to repair damage and to encourage biodiversity and so on and so forth. So I think the UK courts have been increasingly important in bringing to account polluters and providing a deterrent against others that might otherwise have caused pollution. Now, we do have a couple of other questions. I'll just pause for a moment to see whether either Steph or Tom want to add anything to that question. And if not, I will pick this one that seems to be addressed to Tom. Tom, one of your slides mentioned the Environment Bill. Somebody's asking whether you could just touch upon any other provisions relating to water, the key ones in the Environment Bill, that practitioners ought to be aware of.
Yeah, absolutely. So as I said, it's what it doesn't do is fundamentally reform at the moment the framework applying to water management. But what it does do is introduce a number of other things. It introduces the concept of biodiversity, net gain and conservation covenants. And there are also a number of measures in there to tackle specific forms of waste, for example, plastic. There's also a power in there for the Secretary of State to direct water companies to make provision for future demand in terms of water supply. So quite a lot of the provisions are focused around water supply and water supply planning, rather than fundamentally reforming the Water Framework Directive in terms of how the health of rivers is measured.
Thank you, Tom. There has, as you were giving that answer, another question floated in, which I think is for you. Has the UK's transposition of the Waste Framework Directive into English law generally been adequate? And what enforcement action has the Commission taken to date under the Waste Framework Directive?
So I think on the question of the transposition, it is very much really a sort of wait and see moment, because I think it generally has been adequate, but what we don't know is exactly how it's going to be changed or what secondary legislation is going to be introduced. The Water Framework Directive, it obviously sets out a very clear concept in terms of how river health should be measured and monitored. And I think the real question will be whether that approach is fundamentally reformed, perhaps in the way that Sir James Bevan was hinting at. Although I think it's also important to say that those comments that he made attracted a lot of negative coverage. But I think he was really, my reading of it is that he was talking about also the practical impact of how regulators try and decide how to focus their resources. And he was saying that the way that river health is measured can sometimes distort that, perhaps. So it will be interesting to see whether there are any reforms in the direction that he hints at. And in terms of enforcement action, thus far, my understanding is that the Commission hasn't focused so much on enforcement proceedings under the Water Framework Directive, but given that it confirmed that legislation would remain as is in June, and that the focus would be on implementation and enforcement going forwards, I wonder if we might see more of a focus from that, from the Commission going forwards.
All right, thank you, Tom. I think we've got time for one final question for Steph before we wrap up. Steph, you dealt obviously with the Court of Appeal's judgment and the Supreme Court's judgment in Vedanta, and you touched on the interplay between international human rights standards and that Supreme Court judgment. A question is, do you see a tension or even an inconsistency between the two?
I think it's a really interesting question, and it is a subject for, say, maybe a doctoral thesis. I think that it could go either way. My first observation is that, parent companies could start structuring their affairs in a way that means that they are only passive investors, and therefore you can't establish the requisite duty of care for individual claimants. But on the other hand, you could say that these international human rights standards go to an individual company's reputation. And if it goes to their reputation, ultimately affects their bottom line, there might then be an incentive for them to exercise greater control over their subsidiaries. And I think it ultimately comes to the deterrent point that you made in the context of water pollution. I mean, whilst it's fantastic that we have these aspirational human rights standards, how do you enforce them, and how do you build in a sort of deterrent framework? And I see that potentially tort law could provide that vehicle, because if you can have successful claims in negligence and there are financial repercussions, then it arguably and hopefully will mean that you can realise these human rights standards.
Well, there is one, I can't resist trying this question on Tom. It's directed at Tom. I might have a go at it afterwards myself, but I'll leave it first to Tom. A very interesting question. Some jurisdictions have experimented with bestowing rivers legal personhood, and that's India and New Zealand are examples of that. And others have explored given constitutional rights to watersheds, such as in Bolivia and Ecuador. Is this, in your view, a potential development in the United Kingdom?
That is a very interesting question, and I haven't read any commentary that suggests that to date. But it is interesting that the Water Framework Directive very much, conceptually, it's set up so that you're measuring rivers from the outside, and it's all about that monitoring and measuring and collection of data, but it doesn't set up a concept of personhood for those rivers themselves. So, that very different approach that's been mentioned in the question is certainly a very interesting perspective. And Richard, it sounds like you might have something more to say on that.
Yeah, I mean, it's something over the years of practicing environmental law, I have thought about, and it has been debated whether there should be a legal personality in aspects of all the environment as a whole. I mean, some of the delegates who have tuned in might be old enough or have children young enough to remember Dr. Seuss's book, The Lorax. Now, the Lorax speaks for the trees have no tongues. I think the closest we come to providing legal personality to the environment is in instruments such as the Aarhus Convention, because it's through the Aarhus Convention that access to justice is given in environmental cases. The subject matter has to be the environment, but once you get through that threshold, provisions are given to ensure access to justice. The ones that we grapple with most frequently as practitioners relate to costs, but the convention itself goes further than that. And there are special provisions here in the UK and elsewhere that enable mechanisms for shared resources in the environment to become the subject of litigation without prohibitive cost, or without the impediments of other types that one might ordinarily find. So I think there are methods of finding ways of speaking for the trees when the trees have no tongues, to adopt Dr. Seuss's now famous phrase. And whether that is a direct legal personality, such as in India or New Zealand, as the questioner offers as examples, or through other mechanisms, I think that there is the potential for the environment to be protected as a special category of subject matter in litigation. Now, I hope today's session has been helpful. We do appreciate that we increasingly are spending more and more time gazing at screens, and for that reason are particularly appreciative of delegates, of you all, for tuning in. Thank you for that, and please tune in for future episodes of 39 from 39. All the best.